Most people probably think of a business transaction when they hear the word contract, but agreements of a more personal nature, like plea bargains, are also contracts, and the same fundamental contract principles apply, as explained in the 1986 case of United States versus Fentress. The United States government charged Robert Fentress with 1 armed bank robbery, 1 bank robbery, and 6 additional federal crimes. Instead of going to trial, Fentress and his attorney negotiated a plea agreement with the prosecution. Under the agreement, Fentress promised to plead guilty to all 8 charges. In exchange, the prosecution promised to recommend a combined sentence not exceeding 25 years for the 2 robberies, and to recommend that the sentences for the 6 other offenses run concurrently with each other and the robberies. The agreement also contained a merger clause that stated, quote, "This document contains the full and complete agreement between the parties, and no promises or representations have been made except as are incorporated herein," unquote. At the sentencing hearing before the district court, the prosecution recommended prison sentences as described in the plea agreement. But the prosecution also suggested that the court could order Fentress to reimburse the banks for the money he stole, and ask for his prison sentences to start after he finished serving time for a prior, unrelated conviction. Fentress argued that these additional recommendations violated the plea agreement. But the district court accepted the prosecution's recommendations and sentenced Fentress accordingly. Fentress subsequently appealed to the Fourth Circuit.